An appeals court decision is delaying a lawsuit involving brain tumors and cell phones. More than a dozen people have sued cell phone companies, claiming those phones have caused cancer. 8 of them have died since the case was first filed. A judge now says a different legal standard for evidence should have been applied in the case. Let's bring in Wendy Patrick, a veteran prosecutor and trial attorney. Troy Slayton is also with us, criminal defense attorney and former prosecutor. Thanks, both of you, for being here. Wendy, this case has been going on for 15 years. The net effect of this ruling from the appeals court is just going to be to slow it down even more, right?
That's right, John. This case has been a marathon, not a sprint. But could we be discussing anything more important? Do cell phones cause cancer? We know people that sleep with their cell phones, although none of us are going to admit to that. But what happened this week is significant for a couple of reasons. The first is it's about evidence. How much and what kind. The second is the kind of evidence has to do with the evolution of science, because let's face it, when this gets in front of a judge or a jury, they're going to say, show me the science. In other words, how do you know cell phones cause cancer? How can you prove it? And how do you know it caused cancer for the plaintiffs in this case?
Troy, the U.S. government has said there is no conclusive evidence that brain cancer or any kind of cancer is caused by cell phones. Isn't that enough for the companies charged here to win this case?
No. Fortunately, for people that are suing the cell phone companies, it doesn't matter what the federal government or any government says. What matters is, what does the judge allow into evidence before this jury? The judge is the gatekeeper. It's his job to frame what's called the factual universe for the jury. And the judge isn't a scientist. He hasn't done experiments himself. So he's got to decide which standard to use in deciding what evidence can go in front of this jury.
The case, they're asking for almost $2 billion in damages, Wendy. I mean, if they are to prevail, who collects that money? Anybody who's ever used a cell phone? Anybody who's ever had cancer and used a cell phone? How does that work?
Well, you know, when you talk about class actions, it's people that are members of the class. But it's a good question, John, because it deals with the issue of precedent. As Troy and I deal every day in the courtroom, it's a closed universe, but it's also a closed universe evidentiary-wise. In other words, the facts that the court's going to have to consider are very different than what the public is going to be hearing about. That's why we don't try cases in the court of public opinion. We have to do it in a court of law. So regarding who can collect, you bet if this suit is successful, there will be tens of thousands more suits in the future. But remember, even all of that is dependent on the court's decision this week. What kind of evidence is going to be admissible to prove these very important claims that are in front of the judge?
So, Troy, can you explain to us what it is? What is this standard that the appeals court says has to be applied to this case, and how did they come to that decision?
Well, John, I'm admitted to practice in the District of Columbia, and I can tell you that they don't follow, or hadn't in the past, followed the federal rules of evidence, Rule 702, that is also known as the Daubert standard, that 75% of the states follow. Also in California, where I practice, we follow the Fry standard. So even lawyers don't always have this straight. What it basically says is, judges are the gatekeepers. They have to decide whether this evidence is generally accepted in the scientific community and whether it can be retested, whether the expert who's giving his opinions are based on the scientific method and it could be redone, retested, and is generally accepted.
So essentially, Wendy, they said that the 5 experts who testified on behalf of the people who had cancer, the victims who had cancer and who claimed they got that from their cell phones, those 5 experts, their testimony should not have been allowed, boiled down, right?
Well, basically, they're arguing that the court applied the wrong standard in allowing that testimony. The Daubert standard is far more expansive and permissive. In other words, not only can the court consider what they did in allowing those 5 experts to testify, but the court has greater discretion to let in other evidence. So again, the show me the science standard gives the judge even greater leeway to let in more evidence, including some of the evidence that you, John, mentioned earlier. I mean, the court can consider even things that above and beyond what already has been admissible. That's good news for the defendants in this particular case.
It's been going 15 years. Sounds like it could go another 15. We'll see. Wendy Patrick, Troy Slayton, thank you both.